Good morning, David. So today we would be presenting our video on business and corporation law. So my name is Jyoti Chhabra and my student ID is 3020. Our group number is M332 and my other group members are Pranay, Abiral, Ruth and Arthur. So they will be introducing themselves later on. So the first case that we have chosen is the case of Ming, where she is the owner of the hair salon. She has adopted a strategy to cut down the prices as low as $10 to increase more number of customers in her salon. She succeeded with this strategy and more number of people started coming to her salon. But in the long run, she experienced that the expenses that she was bearing on the haircut went higher than the profit she actually was receiving. So in the long run, she has to increase again the prices of the haircut. And what happens next, what are the issues with the cases, what are the laws that are applicable with the cases will be explained by my group members later on. Coming to the next case, that is of business registration. There's a person who wants to open a business as a sole proprietor with his small family. So basically it would be a small scale business about the coffee, but as coffee is in high demand in Australia, so he's pretty sure that in upcoming 5 years the business will grow with huge profits and he'll be able to give employment to more and more staff. So he's pretty sure that in the upcoming years the success rate of the business will be much higher. But what are the issues that are related to this case, and what would be the laws that would be applicable with this case will be explained with my group members later on. Thank you.
My name is Ruth and today I'm talking about the case of Ming, an Australian haircut service business owner who advertises his services by putting a low cost of $10 on his display window. At first he gains profit, but as time goes by he suffers losses and he decides to change the price and put a higher price and an advertisement on his display window. So I'm going to talk about issue 1 and issue 2. Issue 1 is, what will he do with those 40 customers who produce the advertisement before the legal notice of change price is placed on the display window? The relevant law here is the Halsbury's Law of Australia, section 110 of 1, which defines contract as legally binding agreement or promise. The Australian Consumer Law says a promise may become enforceable as a form of the negligence of misstatement, misleading, promissory estoppel, or deceptive contact. According to Australian law, if written evidence is formed between the offerer and acceptor, then the offerer must be liable to follow all the obligations. According to Section 32 of the Australian Consumer Law 2018, a person or a corporation should avoid the communication of process in different intentions for the goods and services. Law application. There is a legal binding agreement where a promise is made of selling the haircut services to the consumer who come with the advertisement of $10. This scenario is similar to the case of Smythe versus Thomas 2007. Conclusion. Ming is liable to serve all these customers with the previous promotion based of $10. He will serve them according to the term and conditions of the promise-based agreement. Issue 2. Either will he serve these 10 people who do not know about his advertisement and want to get the previous base service with the previous cost of $10. Relevant law. According to Australian law, a promise is given in return of a promise. According to the latest guidance for promise and law in Australia, the consideration and the existence of both parties must be available in this agreement. According to Australian contract law, the offers and acceptance of the contract should follow the rules and the regulations properly. The bargaining law is also applied in this scenario. Application. This case is similar to Eliasson versus Enshaw 1819 in Wheaton. There is no consideration of promise in this case. Conclusion. In this case, there is no obligation of the promise-based agreement between these particular customers, so they do not have the right to enforce any argument to Ming. Thank you.
Either Ming is legally liable to serve them with a $10 hairline prices after changing them or not. The relevant law. The bargain theory in the Australian law states that if any party breached the legal agreement without informing another party, then till the new agreement is made, it is liable to cover the entire obligation. The application in this case, contract law is applied where a contract holder is liable to sue another person for his illegal activity to breach the contract on his own will, without informing the other party. Like there may be a case if he talks to his contract holders that he is going to change the prices of the haircut. But he could not do that and in one day then display the new prices of his services. This may impact on the reputation of the customers who advertise his services in the market. So from a legal perspective, he is liable to fulfill his promise. This scenario is quite similar to the case of Carlyle versus Carbolic Smoke Bulk Company back in 1893. In conclusion, it is not the correct way to withdraw from the promotion because according to the contract law, he does not have any right to give argument until he again advertises his new price in the newspaper advertisement.
Hi, my name is Abiral Rai. My student ID is GIA3120 and we are dealing with a scenario where I want to launch a new business and the business is of making coffee and the demand of coffee is continuously increasing among people due to which it is estimated that it will generate a large amount of profit in the coming years. It is a family-based sole proprietor business and it is a small business, starts at a small level. According to the 5-year estimate, this business will grow continuously and the number of employees will increase in the coming 5 years. So the first issue is what type of business entity related registration in the ASIC is more effective for this business today. And according to the section 323D subsection 2 of the Corporation Act 2001, a 12-month rule is applied in this registration phase. If we choose a trust-based entity, then it becomes easy to provide asset protection by limiting the liability in the business-related transaction. And this trust separates the asset control from the owner's asset and makes the transaction more transparent. So it is quite useful to protect the asset or income of this business in beginning years. It is also effective decision because the tax-related expense can be resolved and the profit margin will remains increased. So in this case, it is quite beneficial for me to register the company in the trustee-based business in the Australian market. Thank you.
Hello, my name is Pranay Neopani and my student ID is BCM3066. I am going to talk on the second case regarding the business registration. And on the second case of the business registration, I am going through the issue 2 and the issue 3. Under the issue 2, how the company categorizes at the end of the first financial year and whether it remains the same in upcoming further 5 financial years. Under this, there is the relevant law section 205-2051 of the Australian Corporation Act 201 based on the financial year and the application for the time extension related factors. The Trustee Act 1936 as they apply in the first financial year transaction. Section 197 of the Corporation Act 2001 related obligations will be followed by this new coffee-based company in the next 4 years. And the application is if I change the name of the company in the form of corporation, then the profit margin will become increases. There will be more chances to boost the profitability ratio in the organization. As at the end of the 5th year, there are more opportunities in front of this coffee-based company to expand its operating activities and sell its share to the other people in which there are mutually. And regarding the issue 3, whether this new company can afford to use the brand name of Anzac Coffee in the Australian market. And the relevant law regarding this is there is a case law of the Little versus Australian Securities Commission 1996 HCLC 730. The application is it is legally obliged that if any new company or an existing company use the name of Anzac in a company name, then it must get permission from the Minister for Veterans Affairs. The conclusion: so these companies should not use the ANZAC name in its company's registration. This factor can impact on emotional influences of both New Zealand and Australian people. Thank you.